Welcome to MimiLeaks, where we bring you in-depth readings of topical legal documents, and in today's case, documents involving consequential legal battles of our time. Today, we begin a special series on the 165-page document, Motion for Immunity Determinations. It was filed in early October and is unsealed with some minor redactions. In the motion, Special Counsel Jack Smith argues that then-President Donald Trump did not act in his official capacity when he tried to overturn the result of his election loss, but rather as a candidate and private person. In today's video, I will cover the first few pages of this document. Redactions are abbreviated and they signify named party. I will try my best to address them as they come up. Just know that C and CC both mean conspirator and co-conspirator. They're the same party. P is a person. And again, I apologize ahead of time, but I have been saying co-counsel in my head. And just know if I repeat the error aloud, I mean co-conspirator. So stay with us as we explore this document in portions. And if you like the content, if you like deep dives like this, please make sure to subscribe and hit the notification button to stay informed. So, without further delay, let's begin the reading of the government's motion for immunity determinations in United States v. Trump, as filed on October 2nd, 2024. In the United States District Court for the District of Columbia, United States of America v. Donald J. Trump, defendant. Government's motion for immunity determinations. The defendant asserts that he is immune from prosecution for his criminal scheme to overturn the 2020 presidential election because he claims it entailed official conduct. Not so. Although the defendant was the incumbent president during the charged conspiracies, his scheme was fundamentally a private one. Working with a team of private co-conspirators, the defendant acted as a candidate when he pursued multiple criminal means to disrupt, through fraud or deceit, a government function by which votes are counted and collected, a function in which the defendant, as president, had no official role. In Trump v. United States, the Supreme Court held that presidents are immune from prosecution for certain official conduct, including the defendant's use of the Justice Department in furtherance of this scheme, as was alleged in the original indictment, and remanded to in this court to determine whether the remaining allegations against the defendant are immunized. The answer to that question is no. This motion provides a comprehensive account of the defendant's private criminal conduct, sets forth the legal framework created by Trump for resolving immunity claims, applies that framework to establish that none of the defendant's charged conduct is immunized because it either was unofficial or any presumptive immunity is rebutted, and requests the relief the government seeks, which is, at bottom, this: that the court determine that the defendant must stand trial for his private crimes as would any other citizen. This motion provides the framework for conducting the necessary fact-bound immunity analysis required by the Supreme Court's remand order. It proceeds in 4 parts. Section 1 provides a detailed statement of the case that the government intends to prove at trial. That includes the conduct alleged in the superseding indictment, as well as other categories of evidence that the government intends to present in its case in chief. This detailed statement requests the Supreme Court's ruling that presidential immunity contains an evidentiary component, which should be, quote, addressed at the outset of a proceeding, end quote. Section 2 sets forth the legal principles governing claims of presidential immunity. It explains that, for each category of conduct that the Supreme Court has not yet addressed, this court should first determine whether it was official or unofficial by analyzing the relevant content, form, and context to determine whether the defendant was acting in his official capacity or instead in his capacity as candidate for re-election. Where the defendant was acting as office seeker, not office holder, no immunity attaches. For any conduct deemed official, the court should next determine whether the presumption of immunity is rebutted, which requires the government to show that applying a criminal prohibition to that act would pose no dangers of intrusion on the authority and functions of the executive branch. Section 3 then applies those legal principles to the defendant's conduct and establishes that nothing the government intends to present to the jury is protected by presidential immunity. Although defendants' discussions with the vice president about their official responsibilities qualify as official, the government rebuts the presumption of immunity. And all of the defendants' remaining conduct was unofficial. As content, form, and context show, the defendant was acting in his capacity as a candidate for re-election, not in his capacity as president. In the alternative, if any of this conduct were deemed official, the government would rebut the presumption of immunity. Finally, Section 4 explains the relief sought by the government and specifies the findings the court should make in a single order, namely, that the defendant's conduct set forth in Section 1 is not immunized, and that as a result, the defendant must stand trial on the superseding indictment, and the government is not prohibited at trial from using evidence of the conduct described in Section 1. Section 1. Factual Proffer. When the defendant lost the 2020 presidential election, he resorted to crimes to try to stay in office. With private co-conspirators, the defendant launched a series of increasingly desperate plans to overturn the legitimate election results in 7 states that he had lost: Arizona, Georgia, Michigan, Nevada, New Mexico, Pennsylvania, and Wisconsin, the targeted states. His efforts included lying to state officials in order to induce them to ignore true vote counts, manufacturing fraudulent electoral votes in the targeted states, attempting to enlist VP Mike Pence in his role as president of the Senate to obstruct Congress's certification of the election by using the defendant's fraudulent electoral votes, and, when all else had failed, on January 6, 2021, directing an angry crowd of supporters to the United States Capitol to obstruct the congressional certification. The through line of these events was deceit. The defendants and co-conspirators knowingly false claims of election fraud. They used these lies in furtherance of 3 conspiracies. 1. A conspiracy to interfere with the federal government function by which the nation collects and counts election results, which is set forth in the Constitution and the Electoral Count Act, the ECA. 2. A conspiracy to obstruct the official proceeding in which Congress certifies the legitimate results of the presidential election. And 3. A conspiracy against the rights of millions of Americans to vote and have their votes counted. At its core, the defendant's scheme was a private criminal effort. In his capacity as candidate, the defendant used deceit to target every stage of the electoral process, which through the Constitution, ECA, and state laws includes the state's notification to the federal government of the selection of their representative electors based on popular vote in the state, the meeting of those electors to cast their votes consistent with the popular vote, and Congress's counting of the electors' votes at the certification proceeding. As set forth in detail below, the defendant worked with private co-conspirators, including private attorneys, co-counsel 1, co-counsel 2, co-counsel 3, redacted, and co-counsel 5, which I'll say CC hereafter, and private political operatives, CC6, and person 1, P1. The defendant also relied heavily on private agents, such as his campaign employees and volunteers, like campaign manager P2, deputy campaign manager P3, senior campaign manager P4, and campaign operative P5. In this section, the government sets forth detailed facts supporting the charges against the defendant before addressing the next section, why none of his conduct is subject to immunity under the Supreme Court's decision in Trump. The conduct set forth below includes the defendant's formation of the conspiracies leading up to and immediately following the 2020 presidential election, certain information regarding the knowledge that he had that there had not been outcome determinative fraud in the election as he persistently claimed, and his increasingly desperate efforts to use knowingly false claims of election fraud in order to disrupt the electoral process. The government does not consider any of the following conduct to be subject to the immunity for the reasons set forth in Section 3. A. Formation of the conspiracies. Although his multiple conspiracies began the day after the election in 2020, the defendant laid out groundwork for his crimes well before then. Leading into the election, the defendant's private campaign managers, including P6, then a private citizen, and P2, the defendant's campaign manager, informed him that it would be a close contest and that it was unlikely to be finalized on Election Day, in part because of the time needed to process the large numbers of mail-in ballots prompted by the COVID-19 pandemic. They also told the defendant that initial returns on election night might be misleading. That is, that he might take an early lead in the vote count that would diminish as mail ballots were counted because his own supporters favored in-person voting, while supporters of his opponent, Joseph R. Biden, favored mail-in ballots. Privately, the defendant told advisors, including P6, campaign personnel, P7, redacted, a White House staffer and campaign manager, and P8, the vice president's chief of staff. In that scenario, he would simply declare victory before all the ballots were counted and any winner was projected. Publicly, the defendant began to plant the seeds for that false declaration. In the months leading up to the election, he refused to say whether he would accept the election results, insisted that he would lose any election only because of fraud, and falsely claimed mail-in ballots were inherently fraudulent, and asserted that the only votes counted by Election Day were valid. For instance, in an interview on July 19, 2020, when asked repeatedly if he would accept the results of the election, the defendant said he would have to see and it depends. On July 30th, despite having voted by mail himself earlier that year, the defendant suggested that widespread mail-in voting provided cause for delaying the election, tweeting, quote, "With universal mail-in voting, not absentee voting, which is good, 2020 will be the most inaccurate and fraudulent election in history. It will be a great embarrassment to the USA. Delay the election until people can properly, securely, and safely vote?" Unquote. In an interview on August 2nd, the defendant claimed without any basis that, quote, "There is no way you can go through a mail-in vote without massive cheating," unquote. At a campaign event in Wisconsin on August 17th, the defendant told his supporters, quote, "The only way we're going to lose this election is if the election is rigged. Remember that. It's the only way we're going to lose this election. So we have to be very careful," unquote. In his acceptance speech at the Republican National Convention on August 24th, the defendant said that, quote, "The only way they can take this election away from us is if this is a rigged election," unquote. On October 27th, during remarks regarding his campaign, the defendant said, quote, "It would be very, very proper and very nice if a winner were declared on November 3rd instead of counting ballots for 2 weeks, which is totally inappropriate. And I don't believe that that's by our laws. I don't believe that. So we'll see what happens," unquote. The defendant said this despite, or perhaps because, his private advisors had told him that it was unlikely that the winner of the election would be declared on November 3rd. Oops. Okay. By October 20th, P1, a private political advisor who had worked for the defendant's 2016 presidential campaign, began to assist with the defendant's re-election effort. These 3 days before Election Day, P1 described the defendant's plan to a private gathering of supporters. Quote, "And what Trump's going to do is just declare victory, right? He's going to declare victory. That doesn't mean he's the winner. He's just going to say he's the winner," unquote. After explaining that Biden's supporters favored voting by mail, P1 stated further, quote, "And so they're going to have a natural disadvantage, and Trump's going to take advantage of it. That's our strategy. He's going to declare himself a winner," unquote. Immediately following Election Day on November 3rd, the defendant did exactly that. As his private and campaign advisors had predicted to him, in certain states, the defendant took an early lead on Election Day that began to erode. At approximately 11:20 p.m., Fox News projected Biden would prevail in the state of Arizona, and according to campaign manager P4, he said the defendant was shocked and angry at this development. As Election Day turned to November 4, the contest was too close to project a winner, and in discussions about what the defendant should say publicly regarding the election, senior advisors suggested that the defendant could show restraint and should show restraint while counting continued. Two private advisors, however, advocated a different course. CC1 and CC6 suggested that the defendant just declare victory, and at about 2:20 a.m., the defendant gave televised remarks to a crowd of supporters in which he falsely claimed, without evidence or specificity, that there had been fraud in this election and that he had won. Quote, "This is fraud on the American public. This is an embarrassment to our country. We were getting ready to win this election. Frankly, we did win this election. We did win this election." Unquote. In the immediate post-election period, while the defendant claimed fraud without proof, his private operatives sought to create chaos rather than seek clarity at polling places where states were continuing to tabulate votes. For example, on November 4th, P5, a campaign employee, agent, and co-conspirator of the defendant, tried to sow confusion when the ongoing vote counting at the TCF Center in Detroit, Michigan, looked unfavorable for the defendant. There, when a colleague at the TCF told P5, quote, "We think a batch of votes heavily in Biden's favor is right," unquote, P5 responded, "Find a reason that it isn't, and give me options to file litigation, and even if it is." When the colleague suggested that there was about to be unrest reminiscent of the Brooks Brothers riot, a violent effort to stop the vote count in Florida after the 2000 presidential election, P5 responded, "Make them riot. Do it." The defendant's campaign operatives and supporters used similar tactics at the other tabulation centers, including in Philadelphia, Pennsylvania, and the defendant sometimes used resulting confrontations to falsely claim that his election observers were being denied proper access, thus serving as a predicate to the defendant's claim that fraud had occurred in the observer's absence. Contrary to the defendant's public claims of victory following the election day, his advisors informed him that he would likely lose. On November 7th, in a private campaign meeting that included P2, 3, and 4, and White House staffer P9, who came to serve as a conduit for information from the campaign to the defendant, campaign staff told the defendant that he only had a slim chance of prevailing in the election, and that any potential success was contingent on the defendant winning all ongoing vote counts or litigation in Arizona, Georgia, and Wisconsin. Within a week of that assessment, on November 13th, the defendant's campaign conceded its litigation in Arizona, meaning that based on his campaign advisor's previous assessment, the defendant had lost the election. That same day, in an implicit acknowledgement that he had no lawful way to prevail, the defendant sidelined the existing campaign staff responsible for mounting his legal election challenges. From P2, P3, and others who were telling the defendant the truth, that he did not want to hear that he had lost, the defendant turned to CC1, a private attorney who was willing to falsely claim victory and spread false claims knowingly of election fraud. As the defendant placed alternating phone calls to P3 and CC1 throughout November 13th, P1 informed CC6, another private campaign advisor, of the change, writing, quote, "Close hold, don't tell anyone Trump just fired P3 and put CC1 in charge," and, unquote, and, quote, "You are to report to CC1, unquote." When CC6 asked P2 if P2 was gone too, P1 replied that, quote, "They all report to CC1, and, unquote, and that, quote, P1 had made a recommendation directly that if CC1 was not in charge of this thing, then it was over. Trump is in to the end, unquote." Sorry, it's really hard to read aloud with all these redactions and the punctuations being included in the redactions. So bear with me. The next day, consistent with P1's description, the defendant announced his staff change by tweet, writing, quote, "I look forward to CC1 spearheading the legal effort to defend our right to free and fair elections. CC1, P10, P11, CC3, and P12, and redacted, a truly great team added to our other wonderful lawyers and representatives," unquote. B. The defendant knew that his claims of outcome determinative fraud were false. Following Election Day and throughout the charged conspiracies, the defendant, his co-conspirators, and their agents spread lies that there had been an outcome determinative fraud in the election and that he actually won. These lies included dozens of specific claims that there had been substantial fraud in certain states, such as that large number of dead, non-resident, non-citizen, or otherwise ineligible voters had cast ballots, or that voting machines had changed votes for the defendant to votes for Biden. And the defendant and his co-conspirators continued to make these unsupported, objectively unreasonable, and ever-changing claims, even after they had been publicly disproven or after advisors had directly informed the defendant that they were untrue. The evidence demonstrates that the defendant knew his fraud claims were false because he continued to make those claims even after his close advisors, acting in a non-official capacity, but in a private or campaign-related capacity, told him they were not true. These advisors included P9 as the White House staffer and campaign conduit, and Pence, the defendant's running mate. P9 had a relationship with the defendant that began before P9 worked for him in the White House. P9 had known P13, the defendant's son-in-law, since P13 was a child, and through P13 met P14, and then the defendant. I find it comical when they name, or they redact the name, but then they say defendant's son-in-law. But I get it. P9 was one of several attorneys who represented the defendant in his first impeachment trial in Senate in 2019 and 2020, including presenting argument on the Senate floor on January 27, 2020. P9 began working with the White House as an assistant to the president in August 2020. In October 2020, P9 became interested in learning more about the defendant's campaign, and in early November 2020, he began interfacing with campaign staff. P9 consulted with the White House counsel's office to ensure he complied with any applicable laws regarding campaign activity. Therefore, and thereafter, and throughout the post-election period, P9 became a conduit of information from the campaign to the defendant, and over the course of conspiracies, P9 told the defendant the unvarnished truth about his campaign legal teams and the claims of fraud that they had made and the defendant was also making. Examples of these instances include P9 repeatedly gave the defendant his honest assessment that CC1 could not mount successful legal challenges to the election. For instance, when the defendant told P9 that he was going to put CC1 in charge of the campaign's legal efforts, but pay him only if he succeeded, P9 told the defendant he would never have to pay CC1 anything. In response, the defendant laughed and said, "We'll see." Thereafter, in the Oval Office meetings with the defendant, CC1, and others, in which CC1 made speculative claims, P9 told CC1 in front of the defendant that CC1 would be unable to prove his allegations in a courtroom. In a separate private conversation, when P9 reiterated to the defendant that CC1 would be unable to prove his false fraud allegations in court, the defendant responded, quote, "The details don't matter," unquote. In the post-election period, P9 also took the role of updating the defendant on a near-daily basis on the campaign's unsuccessful efforts to support any fraud claims. P9 told the defendant that the campaign was looking into his fraud claims and even hired external experts to do so, but could not find support for them. He told the defendant that if the campaign took these claims to court, they would get slaughtered because the claims are all bullshit. Quoting him, P9 was privy to the findings of the two experts consulting firms the campaign retained to investigate fraud claims, C1 and C2, and discussed with the defendant their debunking of all major claims. For example, P9 told the defendant that Georgia's audit disproved claims that C3 had altered votes. The redactions saying C are akin to CC. So CC1 is the same as C1. So C is conspirator, I believe, and CC is co-conspirator. In the post-election time period, Pence, the defendant's own running mate, who he had directed to assess fraud allegations, told the defendant that he had seen no evidence of outcome-determinative fraud in the election. This was in one of many conversations the defendant and Pence had as running mates, in which they discussed their shared electoral interests. Pence gradually and gently tried to convince the defendant to accept the lawful results of the election, even if it meant they lost. Their conversations included a conversation on November 4th in which the defendant asked Pence to study up claims of voter fraud in states they had won together in 2016 to determine whether they could bring legal challenges as candidates in those states. Pence described the conversation as follows, quote, "Well, I think it went too broadly. It was just look at all of it. Let me know what you think." But he told me that the campaign was going to fight. The campaign was going to court and make challenges. And then he said, "We're going to fight this and take a look at it. Let me know what you think." Unquote. A call between the defendant and Pence on November 7th, the day that media organizations began to project Biden as the winner of the election. Pence tried to encourage the defendant, quote, as a friend, unquote, reminding him, quote, "You took a dying political party and gave it a new lease on life," unquote. A November 11th meeting among the defendant, Pence, campaign staff, and some White House staff, during which Pence asked when most of the lawsuits would be resolved. Specifically, quote, "When does this come to a head?" Unquote. And the campaign staff responded, quote, "The week after Thanksgiving," unquote. A November 12th meeting among the defendant, Pence, campaign staff, and some White House staff, during which, Pence recalls, the campaign lawyers gave a sober and somewhat pessimistic report on the state of election challenges, unquote. A private lunch on November 12th in which Pence reiterated a face-saving option for the defendant, quote, "Don't concede, but recognize the process is over," unquote. A November 23rd phone call in which the defendant told Pence that the defendant's private attorney, P76, was not optimistic about the election challenges. A December 21st private lunch in which Pence encouraged the defendant, quote, "not to look at the election, as a loss, just an intermission," unquote. This was followed later in the day by a private discussion in the Oval Office in which the defendant asked Pence, quote, "What do you think we should do?" unquote. Pence said, quote, "After we have exhausted every legal process in the courts and Congress, if we still came up short, the defendant should take a bow," unquote. Next page. Discussions in which Pence apprised the defendant of conversations he had with governors in Arizona and Georgia in the context of election challenges, in which Pence called the governors, quote, "simply to gather information and share it with the president," unquote, and in which the governors did not report evidence of fraud in the election in their states and explained that they could not take actions to convene their states' legislatures. But the defendant disregarded P9 and Pence in the same way, that he disregarded dozens of court decisions that unanimously rejected his and his allies' legal claims, and that he had disregarded officials in the targeted states, including those in his own party, who stated publicly that he had lost and that his specific fraud allegations were false. Election officials, for instance, issued press releases and other public statements to combat the disinformation that the defendant and his allies were spreading. At one point, long after the defendant had begun spreading false fraud claims, P15, a White House staffer traveling with the defendant, overheard him tell family members that, quote, "It doesn't matter if you won or lost the election, you still have to fight like hell," unquote. The defendant and his co-conspirators also demonstrated their deliberate disregard for the truth, and thus their knowledge of falsity, when they repeatedly challenged the numbers in their baseless fraud allegations from day to day. At trial, the government will introduce several instances of this pattern, in which the defendant and conspirators' lies were proved by the facts that they made up figures for the whole cloth. One example concerns the defendant and conspirators' claims about non-citizens voting in Arizona. The conspirators started with the allegation that 36,000 non-citizens voted in Arizona, and 5 days later, it was beyond credulity that few hundred thousand. The defendant and his co-conspirators also demonstrated their deliberate disregard for the truth, and thus their knowledge of falsity, when they repeatedly changed the numbers in their baseless fraud allegations from day to day. At trial, the government will introduce several instances of this pattern, in which the defendant and conspirators' lies were proved by the fact that they had made up numbers and figures from whole cloth. One example concerns the defendant and conspirators' claims about non-citizen voters in Arizona. The conspirators started with the allegation that 36,000 non-citizens voted in Arizona. 5 days later, it was beyond credulity that a few hundred thousand didn't vote, is what they said. And 3 weeks later, quote, "The bare minimum was 40 to 50,000. The reality is about 250,000, unquote. Days after that, their assertion was 32,000, and ultimately, the conspirators landed back where they started, at 36,000, a false figure that they never verified or corroborated. Ultimately, the defendant's steady stream of disinformation in the post-election period culminated in the speech he gave at a privately organized rally at the Ellipse on the morning of January 6, 2021, in advance of the official proceeding in which Congress was to certify the election in favor of Biden. In his speech, the defendant repeated the same lies about the election fraud in Arizona, Georgia, Michigan, Nevada, Pennsylvania, and Wisconsin that had been publicly or directly debunked. The defendant used these lies to inflame and motivate a large and angry crowd of his supporters to march the Capitol and disrupt the certification proceeding. C. The defendant aimed deceit at the targeted states to alter their ascertainment and appointment of electors. Shortly after Election Day, the defendant began to target the electoral process at the state level by attempting to deceive state officials and to prevent or overturn the legitimate ascertainment and appointment of Biden's electors. As president, the defendant had no official responsibilities related to the state's administration of the election or the appointment of their electors, and instead contacted state officials in his capacity as candidate. P16 walked the defendant through the margins and the votes remaining to be counted, which were primarily from Pima County, which favored Biden, and Maricopa County, which was split. P16 described the situation to the defendant as, quote, "the ninth inning, 2 outs, and the defendant was several runs down," unquote. The defendant also raised claims of election fraud, and P16 asked the defendant to send him supporting evidence. Although the defendant said he would, stating, "We're packaging it up," he never did. Shortly thereafter, on November 13th, campaign manager P2 told the defendant directly that a false fraud claim that had been circulating, that a substantial number of non-citizens had voted in Arizona, was false. That same day, as noted previously, campaign attorneys conceded in court that the remaining election lawsuit in Arizona was moot. The defendant and CC1 continued to try to influence P16. For example, CC1 tried to contact P16 on November 22nd. The same day, the defendant and CC1 had reached out to the Arizona Speaker of the House, as described below. And on November 30th, the day P16 signed the Arizona Certificate of Ascertainment formally declaring Biden's electors as the legitimate Arizona electors. Instead, later that evening and into the following morning, the defendant repeatedly publicly attacked P16 as well as Georgia Governor P17 on Twitter, retweeting posts by others. And then some of those, I'm going to try to read them correctly with the redactions. Quote, who needs Democrats when you have Republicans like P17 and P16, redaction. And then the quote of the actual person saying it, I believe. Watching the Arizona hearings and then watching Governor P16 sign those papers. Why bother voting for Republicans if what you get is P16 and P17? That's one tweet, I believe. And then another tweet by P17. My state ran the most corrupt election in American history. And then P16. Hold my beer. And also, quote, why is P16 still pretending he's a member of the Republican Party after he just certified fraudulent election results in Arizona that disenfranchised millions of Republicans, unquote. The defendant and co-conspirators also attempted to use false fraud claims to convince political allies in the Arizona state legislature to ignore the popular vote and appoint illegitimate electors. On November 22nd, the defendant and CC1 called P18 the Speaker of the Arizona House of Representatives. CC1 did most of the talking. During the call, the defendant and CC1 levied multiple false fraud claims, including of non-citizen, non-resident, and dead voters that affected the defendant's race, and asked P18 to use them as a basis to call the state legislature into session to replace Arizona's legitimate electors with illegitimate ones for the defendant. When P18 voiced his deep skepticism, CC1 said, well, quote, well, you know, we're all kind of Republicans, and we need to be working together, unquote. P18 refused and asked CC1 to provide evidence supporting his fraud claims. CC1 never did. Indeed, CC1 met with P18 in person approximately a week later and still had nothing to back up his claims. On November 30th, CC1, P12, and others arrived in Arizona for a hotel hearing, an unofficial hearing with Republican legislatures, during which they promoted false fraud allegations. In a meeting a day after the hearing, when state legislatures pressed CC1 and P12 for evidence to support their claims, CC1 conceded that even on that late date, quote, we don't have the evidence, but we have lots of theories, unquote. When the legislators were frustrated that CC1 had no support for his claims and asked him tough questions, CC1 expressed surprise at the way he was being treated, stating, quote, man, I thought we were all Republicans. This is a little more hostile a reception. I'm amazed at the reception I'm getting here, unquote. On December 4th, P18 released a public statement in which he explained that he did not have the authority to use the legislature, quote, to reverse the results of the election, unquote, and that doing so would constitute an attempt, quote, to nullify the people's vote based on the unsupported theories of fraud, unquote. P18 made clear that he was disappointed with the legitimate election results because he, quote, voted for President Trump and worked hard to re-elect him, unquote, but would not, quote, violate current law to change the outcome of a certified election, unquote. On Twitter, P19, a campaign staffer who worked with CC6, attacked P18 for his statement, writing that P18, quote, is intentionally misleading the people of Arizona to avoid the inevitable, unquote. The defendant retweeted P19's false post and praised her. A month later, just 2 days before January 6th, CC2, another of the defendant's private attorneys and a co-conspirator, called P18 and P18 counsel, P20, and urged P18 one last time to use the legislature to decertify Arizona's legitimate electors and overturn the valid election results. When P18 told CC2 that there was no evidence of substantial fraud in Arizona and that he could not legally call the legislature into session, CC2 was undeterred. He conceded that he, quote, didn't know enough about the facts on the ground, unquote, regarding fraud in Arizona, and said that P18 should nonetheless falsely claim that he had the authority to convene the legislature and to let the court sort it out. P18 again refused. In the post-election period, P18 was harassed. On several occasions, individuals gathered outside P18's home with bullhorns and screamed and honked their vehicle horns to create noise. Once, an individual in visible possession of a pistol and wearing a t-shirt in support of a militia group came onto P18's property and screamed at him. At the time of these events, P18's daughter was at home and was very ill, and the noise caused her disruption and angst. That's where I'm ending things today. We'll start next time with Georgia in the same motion and legal document. And thanks for sticking with me, and please subscribe, like, share. Thank you so much for your continued support and subscriptions. I so appreciate it. And until next time, stay safe.